Beyond a Brave New World, Anarchism and Christianity for the Coming Age is brought to you by Iconocast, Jesus Radicals, and Missio Dei.
I'll try to speak up. My name is Carrie Feldman. I'm a local activist. I'm from the Twin Cities. I've been working on different kinds of projects here for 5 or 6 years, starting out with some like prisoner support work, doing sort of animal rights, animal liberation stuff. I've worked on some community center projects in the Twin Cities, including the Jack Pine Community Center and currently the Minnehaha Free Space. And also working on some of the resistance to the RNC. And the reason I'm here talking to y'all today is to share some of my experiences having been subpoenaed to a federal grand jury that was investigating animal liberation actions, refusing to cooperate and spending time in jail. And then also to give some historical background, just more information on the grand jury system, other activists who've been targeted, how it's been used in the past. So, do people have any questions to get started? Okay. If at any point I'm not being clear, you can just raise your hand and ask me a question or check in. So does anyone want to say, does anyone know what a grand jury is? Out there? Hands? People generally know a little bit. And not a lot of people do really understand them. So basically, a grand jury is a panel of people who are convened to hear evidence from a prosecutor and decide whether or not to charge somebody with a crime. They're used on the federal level for any felony charged federally will be heard before a grand jury, and the jury decides whether or not to charge somebody. So theoretically, the idea is that it's a sort of check, it's a sort of protection for people, so that a prosecutor can't just up and decide to charge someone with a crime. They actually have to, have a panel of civilians hear the evidence and decide whether there's enough evidence to actually charge somebody. But throughout history, and even more so in the current day in the last 50 years or so, they've actually been used much more as a tool of the prosecutor to gather information, to coerce people into testifying, to jail people who refuse to cooperate. Really more to gather evidence and to build their cases than to add any protection for people. Because of the way that the system is set up, it allows them to sidestep a lot of what we generally see as our constitutional protections or our rights when we're under investigation. So just some basic things about grand juries. They're a panel of 16 to 23 jurors. The only people allowed in the grand jury room are the jurors, the prosecutor, any witnesses testifying, and a court reporter. There's no judge, and your defense attorney is not allowed to come into the room with you while you're being questioned. They are incredibly secretive. When you're subpoenaed to a grand jury, they don't need to tell you what it is that they're investigating. If you're, they don't need to tell you what information they think you have, really anything about it. When I was subpoenaed, all I got was the subpoena that said, show up in the Southern District of Iowa at this time for your testimony. They're also incredibly secretive in that, obviously no public is allowed in the room. The transcripts from the grand jury are not public, and no one's allowed to talk about what happens in the grand jury room except for the witnesses themselves. You are able, if you need to go outside of the room to ask your lawyers questions in between, but in general, you're not really given access to counsel during this process.
Will that transcript be applied for by the Freedom of Information Act later?
You cannot, no. In my case in particular, I was able to view the transcript as part of my legal proceedings, but it's not public information. It's not free information for anybody, and I would have gotten in trouble if I had shared that with anybody, or could have gotten in trouble. They're also, the major way that they're useful to the prosecutor is that they're allowed to sort of sidestep what people see as their Fifth Amendment right against self-incrimination, or what people see as their right to remain silent. And the way that you'll do that, if you say, I plead the Fifth, I'm not going to testify, they'll grant you immunity. And I'll talk a little bit in depth about that later, but you can be held in contempt of court for refusing to testify. And you can be held either civilly on contempt of court, where you're taken immediately into jail and held until you testify with no trial. It's not a criminal charge. You don't really have any rights as a criminal defendant. They're just taking you straight to jail until you testify. Or you can also, beyond that, be charged criminally with contempt of court, which is a sui generis charge. I don't know if I'm pronouncing that right, but it's not a felony or misdemeanor or any of the typical classifications of charges. It's actually reflective of what it is that they're investigating. So you can serve a long time for contempt of court, depending on what it is that they're asking you to testify about. And there's a lot of discretion to the judge there in deciding how they're going to sentence you if you refuse to cooperate. Does anyone have questions about that?
I thought there was no judge.
The judge, you can challenge it. If you're held in contempt of court, you're taken before a judge. And you have a contempt hearing that's separate from the grand jury investigation itself. Yeah. So the grand jury room, no judge. Contempt of court, that's a separate criminal procedure.
And so if you do plead the fifth and you go before the judge and you say, I'm still pleading the fifth, and they'll say it's contempt.
Yeah. Yeah, you're taken in front of the judge. And I'll talk a little bit later about the process that was for me, and it goes in detail a little more. I just want to give you a general sense before I go into some of the history of where they came from. So the forerunner to the modern day grand jury was developed in England by King Henry II in 1164, and it was called an accusing jury. And basically being accused by this jury was tantamount to a guilty verdict brought down by the crown. They were very oppressive, not really seen as a protection for the people as they're supposed to be. In the 1600s, it was abolished in that form, and people who support grand juries really argue that during that time it became a protection for people. There's a quote that it was, the bulwark against the oppression and despotism of the crown. But even throughout this time, which is like sort of the heyday for, jurors refusing to indict people, they're very easy to manipulate, the grand jury process. They can convene another grand jury in a different area, investigate it again. It's very easy for a prosecutor to manipulate the way the process works, so that if one jury has refused to indict someone, they can just bring it up again and get an indictment later. And so it came over to America with colonization. And in early America, this was seen again, where they'll sometimes reflect the popular political opinions of the day in, refusing indictments, but very rarely, if ever, have they been used to actually protect dissenters or dissidents or people like that from this power of the government and from the power of the prosecutor. So a few examples of when they've been used through history is in the Haymarket Square bombings, which people might be familiar with. The judge actually instructed the jurors in the grand jury that anarchism must be suppressed. And the jurors brought back indictments against 31 anarchists and socialists, even though some of them hadn't actually been there. And 8 anarchists ended up being charged on very weak evidence and hanged. They also brought back thousands of indictments against the labor movement and the Wobblies in the 20s. And during the Cold War and the Red Scare is really when grand juries began to take on more of an investigatory role. So at this time, they basically just weren't really protecting people. Before that, they weren't really protecting people from these arbitrary indictments. But during the time of the Red Scare, rather than just presenting the evidence that they have against people and getting indictments, they began to actually seek out new evidence with the grand jury and use them as a tool to investigate. And one of the ways was subpoenaing people who were the target of the investigation, not just subpoenaing witnesses, people who, the victim of the crime, things like that, but really subpoenaing the targets and trying to get them to testify, trying to make them testify. And a major roadblock at that time was that people would plead the Fifth Amendment, and they'd say, I have the right to remain silent, I'm not going to testify. And at that time, there were they didn't have the ability to force people to testify, and so that kind of stopped them in their tracks. In 1954, compulsory immunity was established, and And even then, it was only in specific cases, but they would give you immunity from prosecution in matters of national security so that you would have to testify and you couldn't plead that you were going to incriminate yourself because you were immune from prosecution. And President Eisenhower, when they passed this act, said, "This act provides a new means of breaking through the secrecy which is characteristic of traitors, spies, and saboteurs." But even at that time, the act wasn't used very much and really came into play later during the 60s and 70s when the Organized Crime Control Act was passed, and that broadly expanded the way that they could use immunity, the way they could force people to have immunity, so that you were no longer immune from prosecution overall for a crime, but you were just immune from them using your words against you. So they could still subpoena two people to testify against each other, force them to testify, and they've both been incriminated by their, the other person's testimony. It's just your individual words can't be used against you. So it's not very much of a protection for people. During the 60s and 70s, grand juries were used against, movements across the board: student activists, Vietnam veterans, the Catholic left, weathermen, anti-draft movements, academic community, women's movements, black national movements. Across the board, very many movements were targeted with grand juries. And at first, people didn't really know what to do. It was pretty scary being threatened with, contempt, being threatened with incarceration. And they sort of floundered. But at some point, people really came to the consensus that the only way to deal with grand jury investigations was a strategy of total non-cooperation. And that was the main tactic that was used at that point. And people were, jailed en masse. When people, hundreds of people would be subpoenaed to a grand jury, they would all refuse to testify and they'd be taken to jail. So some of the reasons that people wouldn't testify, when it's, a lot of times these are fishing expeditions. They go and subpoena a lot of people trying to get information about, a movement, about, in a lot of social movements there are above ground and underground aspects going on. There's different kinds of activities. And so they'll subpoena people in above ground areas, see if they can get more information, see if they can broaden their investigation. And so even if people didn't know, even if you don't know that you have information that's useful to the police, you might have information that they can use in that investigation that can help them bring somebody else in, or that can help them subpoena someone else. If you mention a name, they'll subpoena another person to the grand jury. In a grand jury, they can ask you about information that's not normally admissible in court. Certain protections that you generally have, privacy things. There's very few standards for evidence in a grand jury. Hearsay is allowed, evidence about medical, things like that are generally not. They also, perjury, lying, and on the stand is a felony crime. You can get 5 years in prison. And so if they can twist your words, if they catch somebody in a lie, it's just very dangerous to go into a grand jury and try to testify and just not incriminate anybody or try to, get around answering their questions or anything like that. And that's why people really came to this consensus that you should not cooperate and not testify at all in a grand jury. I did a little bit of research about some of the specifically Catholic, Christian instances of grand jury investigations. And it seemed like there definitely is a history there of resistance. Some things where people were visiting prisoners and asked to testify against the prisoners. People had refused to cooperate in that. There were some civil disobedience actions, actually as recently as 2004 in Iowa, that a number of people were subpoenaed to testify about and refused to cooperate, ended up getting the subpoenas quashed. A lot of times through a big media campaign. One of the only ways you can really fight a grand jury, because you have so few legal protections, is to make it very public what's going on, kind of destroy their secrecy, and sometimes they'll just drop it. So since then, grand juries have continued to be used heavily against Puerto Rican independence activists and black nationalists. A few months ago, I actually got to speak on a panel with Jose Lopez, who is a Puerto Rican independentista who spent 7 months in jail for refusing to cooperate in 1976. So that was pretty cool to share, get to be on the same panel with him. What?
Question: Do people still today agree that you should cooperate?
Yes.
That's still.
Yes, that is still the consensus. And I'm going to get to some of the recent major cases today. So most recently, some of the major targets of grand juries have been earth liberation and animal liberation activists during the 90s and early 2000s. As part of the Green Scare, are people familiar with the term Green Scare? Anybody? Does someone want to explain what it is? No? Okay. Well, Green Scare is a term that was coined to describe a sort of systematic harassment of environmental activists. It's echoing the Red Scare of the 50s. And large numbers of raids, arrests, investigations around the radical environmental movement. There's examples like Craig Roseborough, who was the spokesperson for the Earth Liberation Front, was subpoenaed 8 different times to grand juries and refused to testify. One major current case that's local here is the subpoena of anti-war activists in Chicago, Minneapolis, a couple other places in the country. Dozens of them were subpoenaed originally to a federal grand jury investigating material support for terrorism because of some of the international solidarity work that they were doing. And they have all across the board refused to cooperate with the grand jury via, at this point, none of them have been called in to the physical grand jury yet. They refused via a letter from their lawyers to the prosecutor, and their subpoenas were put on hold. But it's likely that some of them will be resubpoenaed, will be asked to come in front of the grand jury, and will likely face contempt of court. If you want more information about those people and their case and what's developing with that, you can go to stopfbi.net is their website. One thing I also wanted to highlight about grand juries is I've talked a lot about their use against, social movements, activists throughout history. But they're also used very coercively against just regular people. During my time in jail, I talked to other people about their experiences with grand juries, and it's very common to, for example, subpoena people's family members in drug cases and force them to testify against the person under threat of spending time in jail. Things like that. The coercive power and the threat of incarceration is incredibly powerful for the prosecutor. So, do people have questions about that history? Anything like that?
How much time do you spend in jail?
I'm going to talk about my case next. That's okay.
Are they on federal, state, local level?
There are federal, there's federal grand juries, mostly are what I'm talking about, and especially in terms of some of the specifics. Some states do have state grand juries it depends what kind of crimes, that they're all different. And they have different rules, but Minnesota actually does have state grand juries.
How does one become a member of a grand jury?
It's like being in a regular jury pool. You get called to serve. But unlike the screening processes are different than a regular jury pool, which gives the prosecutor a lot more power, again, in choosing who sits on the grand jury. Because there's obviously no defense attorney in there to challenge who's on there. Any other questions? Can people still hear me in the back there? Yeah? Okay. All right, well then I'm going to talk a little bit about my case being subpoenaed to a grand jury, as well as my co-defendant, Scott Demuth. So I was subpoenaed October 2009. I had just left my house and I was driving. I got pulled over actually right across the street from Walker Church. And 2 federal agents got out of the car and just, asked me to roll down my window and said, Carrie? I was like, yeah. And they handed me this piece of paper and said, you're being subpoenaed to a federal grand jury in Davenport, Iowa. And explain some of the logistics. They didn't say what it was that I was being investigated for, why I was being called to testify. They didn't give me any information about what was going on. And at the time, I had no idea. I had never been to Iowa before, so it was pretty confusing. But I took the subpoena. I didn't talk to them. And I called my lawyer right away, and I got a hold of some friends who had done prisoner support, legal support work before. Like I mentioned, I was part of a Earth Liberation Prisoner Support group called EWOC. And after doing some research, knowing that they were investigating something in the Southern District of Iowa and that they were investigating something that happened in 2004, it became pretty clear that they were investigating an animal liberation that happened in 2004 in Iowa, where people had broken into the university and released a number of mice and rats that were being used for testing. The crime was nearing its statute of limitations, and so it was pretty clear that they were in an effort to solve that case before the statute was closed. They subpoenaed me, hold on, I'm getting some water. They subpoenaed me to appear 2 days later in Iowa. So basically I had to leave, after I got the subpoena at 4 or 5 o'clock, I had to leave for Iowa the next day to go down there and testify. Right away when I got the subpoena, I had heard of grand juries before. I had heard of some of this history of especially environmental and animal movements being targeted. And so I was sure right away that I wasn't going to cooperate with the subpoena, that they were probably investigating something regarding one of the movements I've been associated with, and that I wasn't going to testify, I wasn't going to help them get a conviction. So I drove down to Iowa with a couple of friends, and the way that I decided to resist, there's been a lot of different ways in the past. People have just not shown up, they've held press conferences, different kinds of things, but I decided to go into the room and read a statement about why I wasn't going to testify before the grand jury. So that's what I did. I have the statement here if people want me to read it. Yeah? Okay. So I got called into the room. It was just, I got a public defender. It was just me there with the prosecutor and the jury. First of all, I would like to state unequivocally and most certainly for the record that I have no intention of testifying before this grand jury. Based on information from the prosecutor indicating that I may be a target of this investigation, I am invoking my Fifth Amendment right against self-incrimination. But beyond that, I'm refusing to cooperate based on a sincere belief that to do so would run counter to my deeply held convictions and values. Grand juries were originally created to prevent arbitrary indictments, but are now used as a tool of the prosecution to gather information. Grand juries undercut basic rights supposedly granted in the Constitution by denying access to counsel and coercing testimony. They are now, and have been for some time, used to investigate and intimidate those who would express dissent. This is only effective when we are complicit, when we are frightened, when we are divided. Today my voice may waver as I stand alone in this room, but I know I speak with the voice of every one of my friends, loved ones, and comrades when I say this. We will not be intimidated. We will not cooperate. I have nothing more to say to you. I read the statement after they had tried to ask me a few preliminary questions, and I was kind of like, I'm not going to testify. I have a statement about it. And I didn't actually think they were going to let me read a statement. I kind of imagined this dramatic scene where they're like, what are you doing? You're out of order, like drag me out of the courtroom or something. But they just sat there and let me read the whole statement. And then the prosecutor tried to ask me a couple more questions, in particular about things that I had posted on the internet about being subpoenaed. He was very aggressive in saying that you don't have the right to just not testify, that I'm going to hold you in contempt of court if you do this. He threatened that they were going to give me use immunity. But it actually is sort of a procedure for them. They have to get approval from the federal agents in Washington or wherever to give somebody immunity. So they actually didn't take me to jail that day. I walked out of the courtroom and they just handed me another subpoena to come back a month later. With the implication that at that time I would have immunity and that time I would be taken to jail. So during that month, I had some time to, work with people who were supporting me to get ready for going to jail. Also during that month, another person got subpoenaed to the same grand jury on the same day. and that was Scott Demuth. Scott was my former partner. He was a student of sociology at the University of Minnesota, and also an activist in the Twin Cities. We were scheduled to appear on November 17th. We had made it pretty clear to the prosecutor and publicly that we weren't going to testify at that time. So when we went down the second time, we were taken straight into a contempt of court hearing rather than into the grand jury room itself. In that hearing, there's not a lot you can argue about it. It's basically you're not testifying, you're in contempt of court. We did try to make some arguments because it's at the discretion of the judge. They don't have to send you to jail. It's the judge may confine you. So we made some arguments that, they hadn't provided any evidence against me, that I was needed in my family because I was taking care of my grandmother at the time who has Alzheimer's. But the judge didn't really listen, ordered me in contempt of court, and sent me to jail right then. Oh, the other thing, actually at that time, my dad was the one testifying about how I was needed in my family, and the prosecutor used that as a chance to question my dad about me, but didn't ask very much. He asked, "Is your daughter an anarchist?" And my dad said yes. And he asked about a picture of me from my MySpace page when I was like 16 years old, where I was wearing a shirt that said ALF. Well, you could only see LF in the picture, and I had a pet rat. And he asked, could this shirt have said ALF? My dad was like, I don't know if it could. And he asked about the rat, where I got it, like implying that I had stolen it from the University of Iowa when I was 16. But that was all he really asked, and then I was taken to jail. The rat's name was Bandit. Yeah, he actually knew the rat's name because it said it on the MySpace page. It said, "This is me and my rat Bandit." I got it at a punk show, if you're wondering. But we were both held in civil contempt of court. We both refused to testify. And a few days later, Scott was actually indicted on the they charged him with the University of Iowa raid. And he was charged under the Animal Enterprise Protection Act, which has anybody heard of the AEPA or the AETA? There are two pieces of legislation. I believe the AEPA was 2003. Anyway, in the early 2000s that were passed that harshened criminal penalties for crimes that were committed against animal enterprises. So even though it's already a crime, to release animals because of, it's burglary or property destruction or something like that already, it's more of a crime if you're taking these actions against an animal enterprise. And this was legislation that was enacted in response to the animal liberation movement that was lobbied for by animal industries. And he was charged under the Animal Enterprise Protection Act. A few years after that act was passed, they passed the Animal Enterprise Terrorism Act, which increased the penalties further and really broadened that law, and had the crucial element of adding the T word and equating animal liberation and releasing animals with terrorism. So his indictment was incredibly vague. It didn't even actually mention the University of Iowa. It just said that they were charging him with conspiring on or around November of 2004 in Iowa or elsewhere to violate the Animal Enterprise Protection Act. But he was facing 3 years at that time under the AEPA. Had it been applicable under the AETA, which was passed after the crime occurred, he would have been facing 10 years for the same crime. That's how much it stepped up the sentencing because of the political nature of the crime. So Scott was, after he was indicted, he was released on home monitoring. And I continued to be held in jail, despite that they had already issued an indictment. So I tried to challenge on different legal grounds, but continually failed. You have very few rights when you're being held in civil contempt of court. The prosecutor's main argument was just that I had no due process rights, that if I wanted to get out of jail, I could testify and I would get out anytime, that I wasn't a criminal defendant. And he didn't really have to prove anything or tell me anything about why they still needed my testimony. I was held for a total of 4 months, although on civil contempt, you can be held for up to 18 months. And there's no rule after that, if you're released after 18 months, that they can't call a grand jury again and subpoena you again and begin the process over. Although there are, the major legal challenge that you can file against civil contempt is a grumbles motion, where basically with civil contempt, they're trying to coerce you, they're not trying to punish you, and that's why they're allowed to do this without any kind of trial. But if you can argue that you're never going to testify and there's no way you'll ever cooperate, holding you in jail as long as they want is only going to be punishment, then they can't hold you on civil contempt of court. And a few people have successfully made that argument, only to be charged with criminal contempt of court, which they have a pretty good case for because you just argued that you would never ever testify.